Okay, good afternoon, everyone. I can't see who has yet joined us, but I can see that there's quite a number of participants. I'm just going to give it another couple of minutes before we get started, if that's okay, just to let a few more people join us, and then we'll get going. Okay, good afternoon, everyone. I think we're up to quite a number of people now, so we probably should get started. It's just gone past. Thank you to everyone for joining us. My name, for those of you that don't know me, is Andrew Webster. With me this afternoon is my colleague, Tim Wilkinson. I think we know most of you, actually, but for those of you that don't know us, we've both been practicing this area for, well, longer than we care to remember, certainly well over a decade by now. The plan, we hope, is to speak for around about 50 minutes, though I suspect we both probably said that before. But either way, hopefully there'll be time for some questions at the end. On that subject, for those of you that don't use Zoom webinars regularly, there's a Q&A function at the bottom of your screen. And if you pop your question in there, we'll try to keep an eye on it and come back to it at the end. So, as you can see from the title slide, today's talk is about causation in whistleblowing cases. I suspect that many of you are probably dealing with whistleblowing cases regularly, but we appreciate that's not necessarily the position for all of you. So for those of you less familiar with this area, there are two principal rights to have in mind from the outset, the first of which is the detriment right, which is the section 47B provision, that a worker has a right not to be subject to a detriment done on the ground that he has made a protected disclosure. And the second principal provision is the unfair dismissal provision, i.e. section 103A, that a dismissal will be automatically unfair if the reason or principal reason is that the employee made a protected disclosure. In terms of the meaning of the protected disclosure itself, strictly speaking, that's beyond the scope of this talk. But very briefly, for those of you who may not be familiar, the relevant provisions are sections 43A to 43L of the Employment Rights Act. And under section 43B1, what we're concerned with is the disclosure of information which, in the reasonable belief of a worker, is made in the public interest and tends to show one or more of various matters. Examples include that there's been a breach of a legal obligation or that someone's health and safety has been endangered. Very often, in my experience, disclosures are said to have been made to the employer, and that's covered by section 43C, but they can be made in certain circumstances to various others, including ministers and the like. So that's a very cursory run through of the meaning of a protected disclosure. But if you are dealing with these issues infrequently, I would encourage you to look carefully at the legislation before forming a view about whether, in fact, you do indeed have a protected disclosure. Returning to the PowerPoint itself, Certainly my experience, Tim, is that this is an area in which there are increasing numbers of claims, both dismissal claims and detriment claims.
Yes, which is my experience as well. Thanks, Andrew. Good afternoon, everyone. Certainly, I've found there's been an increase over the last couple of years, probably because, as we've said out there, that there's no 2-year qualifying period. So we're seeing more and more. They can be complex, often lengthy hearings because of that, and often involving a considerable number of issues, such as whether a disclosure is protected or not, which Andrew's touched on. There are always, it seems, issues as to causation in whistleblowing claims, which is one of the reasons why we thought we'd discuss it today. And I'm going to start by discussing causation in detriment cases. We have separated the two, detriment and unfair dismissals, because there is a difference. And I'm going to touch on detriment. As I said, it's set out there, first bullet point, section 47B1. Worker has the right not to be subject to any detriment by any act or failure to act by his employer done on the ground that the worker has made a protected disclosure. So the key words there are on the grounds that. It isn't a book 4 test, as we can see there in Harrow, London Borough. It is what does on the ground mean? It means materially influence. What does materially influence mean? Well, Fessett and NHS Manchester tells us that it means more than a trivial influence. The case of Fessett that I've listed there is well worth a read for anyone who's dealing with whistleblowing cases, particularly where causation is problematic. You'll all have heard of it, no doubt, maybe sometime since you read it. But it is a useful judgment. It's Court of Appeal, Lord Justice Elias. The case itself involved a disclosure against or in relation to someone called Mr. Swift. Not long after the disclosure, the workforce divided into those who supported each of the camps and those who were more neutral on the point. It led to grievances, counter grievances, and a situation that the tribunal described as dysfunctional. And eventually the respondent decided the only solution was to remove Fessett and a colleague from their substantive posts. But in that particular case, it was said that the disclosures themselves had played no part in the detrimental treatment, that Fessett had been moved not because of the disclosure, but because the workforce was no longer functioning, and that was the only option available. So a book 4 test perhaps would have worked, but for the disclosure, the workforce wouldn't have been dysfunctional and she may not have been moved, but that was not the test. The test is whether it was materially influenced. So I'm just going to pass over to Andrew.
Thank you, Tim. So moving to causation in an unfair dismissal context rather than a detriment context. But before I get to causation test itself, I just want to touch briefly on section 47B2. And as we can see, what that provides is that in the case of an employee seeking to bring a claim against their employer in relation to dismissal, the relevant claim is a section 103A claim, i.e. it's a dismissal claim, it's not a detriment claim in those circumstances. But I will come back to that issue later on because there is a slight nuance to that point in a certain circumstance. So coming to causation itself, under section 103A, what we're looking for is the reason or principal reason for the dismissal. In other words, the same test that applies in an ordinary unfair dismissal claim under section 98, sometimes referred to as the sole or principal reason test. And with that in mind, I've included the famous quote from Lord Justice Keynes and Abernethy, which I won't read out to you. And what will be immediately apparent moving to the next slide is that the detriment test and the unfair dismissal test are different. And in particular, the dismissal test is likely to be more onerous for a claimant to surmount. In the case of Mott, that was neatly illustrated in a circumstance in which the ET wrongly applied the material influence test. That was given short shrift by Heather Williams in the EAT and was swiftly overturned as being the wrong test. Similarly, in the case of IGA, the ET gave itself a direction that what it was concerned with was whether the making of the disclosure was a matter which was in the employer's mind at the time of dismissal. And it found that it was in the employer's mind, and it therefore heard the dismissal to have been unfair. Again, the EAT was unimpressed with that gloss or alteration to the test, and Mrs. Justice Slade made plain that it was the wrong approach. So what we're looking for on the face of it is fairly straightforward, the sole or principal reason in the case of dismissal. In terms of the question of the link to a particular disclosure, I've included this because in my experience is a practical issue which routinely comes up. A claimant will say, for example, I've made 10 disclosures and I was subjected to 20 detriments. What the claimant doesn't say is, well, which disclosures connect to which detriments? How should the ET approach that issue? How should we as practitioners analyse that issue? Well, in the case of Black Bay and Gahir, there was some general guidance given on whistleblowing cases, and it deals with this issue. Ms. Gahir was a pharmacist who, quite impressively, I think, within 11 days of starting in post, managed to get herself dismissed in circumstances in which she'd sent a series of emails in which she asserted that she was raising various health and safety concerns that the company's standard operating procedures were non-compliant with statutory requirements and the like. And I should add in passing, because it's relevant, that she widely disseminated those emails, and the tone in which she expressed her views was not mild, to put it that way. Anyway, she brought a claim in the Employment Tribunal, which went on to uphold a claim of unfair dismissal and detriment, I should say, which the Employment Tribunal went on to uphold. You might wonder, well, what's the detriment in those circumstances where she's only there for 11 days and she gets dismissed? But what the Employment Tribunal found is that having raised these serious issues, the employer failed to properly address them in that 11-day window, and that led to the claimant experiencing stress, which amounted to a detriment. So to be clear, that's an omission case, not an act case. It's not a case in which the employer is said to have done something specific. It's a case in which it's not done something. Of course, in this context, we must remember under 47B1 that omission has to be a deliberate omission. So that was the finding of the ET. Perhaps unsurprisingly, the employer appealed, and the EAT, Judge Sirota, overturned the decision insofar as detriment is concerned. It didn't incidentally overturn the unfair dismissal finding, albeit it had misgivings about it, but it overturned the detriment claim. And in essence, what they concluded was that it was perverse to find on the facts that an employer had made a deliberate decision not to act on the concerns in such a short window. So as an aside, it's quite a useful case on deliberate failure to act. But of greater interest today, however, is the guidance that it gave more generally that I mentioned. It appears in particular at paragraph 98 if you're looking at the judgment. And what Judge Sirota said is this: it is not sufficient, as here, for the Employment Tribunal to simply lump together a number of complaints, some of which may be culpable, but others of which may simply have been references to a checklist of legal requirements or do not amount to disclosure of information tending to show breaches of legal obligations. Unless the Employment Tribunal undertakes this exercise, it is impossible to know which failures or likely failures were regarded as culpable and which attracted the act or omission said to be the detriment suffered. That having been said, he did also add, it is of course proper for an ET to have regard to the cumulative effect of a number of complaints, providing always they've been identified as protected disclosures. And that point arises from the El Magrizi case, which is referenced in the Gahir judgment. In short, therefore, what the employment needs to do is identify clearly each disclosure, and it needs to identify which disclosure attracts the particular act or omission resulting in detriment. That said, it is legitimate to consider, having identified each of both, whether the cumulative effect of a number of disclosures has led to an act or omission. Turning to the question of vicarious liability, which I appreciate is a slight segue just before I hand back to Tim for a bit, but I thought it was useful to mention this. Certainly my experience is that in discrimination claims, one often sees claims being brought against individuals as well as employers. But in whistleblowing claims, I see that far less frequently. That's despite the fact that since 2013, there has been explicit statutory provision enabling detriment claims to be pursued against individuals. Section 47B(1)(a) provides that a worker has the right not to be subjected to any detriment by another worker, and 47B(1)(b) makes the employer vicariously liable for the same, subject to a statutory defence, reasonable steps defence of the like one sees in the Equality Act. And then Section 48 provides the right to bring such a claim in the tribunal. Now, we already know that pursuant to 47B(2), in the case of an employee complaining about dismissal, that's a Section 103A claim, not a Section 47B detriment claim. But I mentioned a slight nuance to which I said I would return. What about the situation in which an employer worker wants to bring a claim against a worker in relation to dismissal, so against a worker, not the employer? A worker can't be liable for unfair dismissal, so the Section 103A claim can't be brought. Can the employer worker in that situation bring a detriment claim against the worker in respect of their dismissal? That was the main question the Court of Appeal considered in the case of Timmis. And it was held in the judgment, the main judgment being given by Lord Justice Underhill, that such a claim can be pursued against an individual. Theoretically, of course, that gives rise to the possibility of an employer then being vicariously liable for the detriment of dismissal, despite the operation of 47B(2). And the point was made by counsel for the employer arguing against this, that this would effectively make Section 103A redundant, or OTOs. But Lord Justice Underhill was unimpressed by that submission and made the point that Section 103A is an automatic provision, whereas the provision in respect of workers is subject to a reasonable steps defence. So for that reason, I would think it's fairly unusual circumstances that one seeks to pursue such a claim. Certainly as a freestanding claim, one might have it as an adjunct to a 103A claim, but more likely one is going to pursue the 103A claim. And at that point, I think I would hand back to Tim to deal with the burden of proof.
Thanks, Andrew. So how does an employment tribunal approach causation in whistleblowing cases? The burden of proof can be particularly important, I think, in these sorts of cases. I'm going to deal with detriment and then dismissal. Looking at detriment, you can see it set out there, Section 48(2). On such a complaint, it is for the employer to show the ground on which any act or deliberate failure to act was done. So the employee has to show that they have made a protected disclosure and that there has been a detriment, and thereafter it's for the employer to show the ground on which that act is done or the deliberate failure to act was done. And that's something I think that sometimes gets forgotten in whistleblowing cases. But what if the employer doesn't show that ground as is required in Section 48(2)? Well, then the tribunal may, as you can see there in the second bullet point, may draw an adverse inference against the employer. It's not inevitable, and Serco that I've listed there tells us that. Serco, I mentioned Fessett earlier as one to read. Serco's probably another one to read if you've got a case such as this coming up. It was actually to do with trade union activities, but is nevertheless useful in whistleblowing cases. It dealt with detriment and dismissal. And in relation to both of those, the Court of Appeal said, it doesn't automatically follow that a claimant will succeed, even if the employer fails to show the ground on which an act is done. The comment from the Court of Appeal was that usually, no doubt it will, but just a gentle reminder that these are fact specific. It's based on the direct evidence and the inferences that can properly be drawn from that evidence. So it's not inevitable, but inferences may be drawn. And that can, as I say, be particularly useful in these sorts of cases. I, perhaps unusually for me, was acting for a claimant in a whistleblowing detriment claim recently. There were a number of allegations, number of detriments over a lengthy period of time. And following the hearing, the judgment was to the extent of the explanations provided by the respondent either weren't there or weren't accepted by the tribunal. They were sufficiently undermined that the tribunal felt it couldn't and didn't have to and couldn't accept that evidence provided by the respondents in relation to the grounds on which these detriments had occurred. In that case, on those facts, the tribunal felt that it could draw inferences, and the claimant succeeded on a number of grounds, and the burden of proof was a significant factor in that. So just turning then to unfair dismissal cases, most of you will know the burden of proof in terms of providing the reason or the principal reason is on the employer, unless the claimant doesn't have the qualifying period, as we've set out in that slide. I've referenced Causation there. Causation actually is discussed in Serco. So if you're going to read one of them, probably better to read Serco than Causation. But it does tell us that it's for the employee, firstly, to put in issue the reason for the dismissal, but thereafter the ET is going to hear and consider evidence from both sides, and it's going to make primary findings of fact as to the reason for the dismissal. Again, even if the respondent's reason isn't accepted, it doesn't automatically follow that the claimant's purported reason or the reason put forward by the claimant, i.e. the disclosure, is going to succeed. The Court of Appeal said, actually, it could be a reason that neither side has put forward, albeit that, as we can imagine, that's probably a relatively rare circumstance. So that deals with burden of proof. I'm going to turn to the separability principle. I'm going to deal with this generally and then in the context of Kong in due course. Now, the separability principle type cases can be tricky. And essentially what we're looking at is whether the protected act can be separated from the features or the consequences of the raising of that act. We can see it there in the first bullet point. There's no liability if it can be shown that the reason for the act or omission was not the protected act as such, but one or more features and or consequences of it, which are properly and genuinely separable. Now, I'm going to come back to the phrase properly and genuinely separable when I move on to Kong. But we can see there, I've listed the case of Martin and Devonshire solicitors. Many of you will be familiar with it. You'll recognise the name, if not having read the judgment yourselves. But just by way of brief background, it was a victimisation claim, actually, but it is relevant to whistleblowing cases. The claimant was a legal secretary. She raised a grievance which referenced previous ET proceedings, but also raised allegations against a couple of the partners at Devonshire's. Devonshire's initially considered this grievance to have been made in bad faith and to be malicious, but the medical evidence which was subsequently obtained divulged a history of mental health and suggested that the subject of the disclosures were probably auditory hallucinations on the part of the claimant. Not surprisingly, Devonshire's didn't pursue the suggestion that it was made in bad faith or maliciously, but the problem was that the claimant continued to insist that those allegations were true, and eventually she was dismissed, ostensibly because there was a breakdown in the relationship between her and her employer. The tribunal reminded us it's not a but-for test. We're considering the substantive or the operative reason. And the tribunal explained that sometimes it may be necessary to explore what it is about the particular grievance, how it was advanced, or what the wider circumstances were. And in this particular case, it wasn't the making of the allegations of discrimination which led to the dismissal, or the sole or principal reason for the dismissal. It was a combination of other factors separable from the disclosure, factors such as the seriousness of the allegations, the repetition, the refusal to accept that the allegations were false, and the likelihood of those allegations continuing. The claimant appealed, the EAT upheld the original decision and said, yes, there may be cases where an employer can legitimately say it's not the complaint, but it's some feature of it. And that takes us back to the Devonshire case and whether something is properly and genuinely separable. These distinctions can be subtle, but they are real and they can be made in the right case. Now, in terms of Martin and Devonshire, one of the things that the EAT mentioned is there's a phrase, wholly unreasonable acts. And it said, an employer relying upon simply ordinary unreasonable behaviour should be treated as objecting to the complaint itself, and tribunals should be slow to make a distinction. So when we're looking at whether something is properly and genuinely separable, and perhaps the manner in which the disclosure is raised, if it's raised in a manner which is ordinarily unreasonable but not wholly unreasonable, an employer should be treated as objecting to the complaint, and the ET should be slow to separate the two and make a distinction between the two. And that wholly unreasonable acts is something that I'm going to again come back to when I discuss Kong. But before I do, the two further cases on that slide, Bolton School and Evans. This was a claimant who hacked into the IT system effectively in order to show that it could actually be done. The ICT department, thinking quite rightly that it had been hacked, shut the systems down, and that led to costs ranging, I think, in region of about £1,000. The tribunal said the hacking was part and parcel of the disclosure and therefore couldn't be separated, but the EAT disagreed with that and said actually the claimant here wasn't dismissed because of the disclosure or for the disclosure. He was dismissed for hacking into the system without the authority to do so. And that in that respect, there could be and was properly a distinction made. The case of Panayutu and Chief Constable of Hampshire Police, a number of disclosures were made, but the claimant went beyond those disclosures and thereafter campaigned what the tribunal described as relentlessly for action that he thought was necessary on the back of those disclosures. He believed in cover-ups and he sought support from his colleagues in relation to the campaigns or the action that he wanted. And it led to a situation that the tribunal described as completely unmanageable. It went to the EAT, and the EAT said the tribunal was entitled to make the distinction it did. In this case, the dismissal was not, or the sole or principal reason for the dismissal was not the disclosure, it was the huge amounts of management time that had been involved with the campaigns that followed on from the disclosures, and a secondary reason that for health reasons, the claimant was no longer a functioning police officer. So again, we can see that there's been a separation with the disclosure from features of that disclosure. So that takes me on to Kong and the separability principle in relation to Kong. And now Kong deals with two issues, separability, which I'm going to touch on, and attribution principle, which Andrew is going to come back to in due course. Now this case went to the Court of Appeal, judgment at the end of last year, and many of you again may have seen the name if not read the case yourselves, but just by way of brief recap, the claimant was a head of financial audit. She raised some concerns about the adequacy of a legal agreement, and the head of legal expressed a different view. The head of legal disagreed, not surprisingly perhaps, because it was she who was responsible for drafting the agreement in the first place. That led to a conversation between the head of legal and the claimant, and also a subsequent email from the claimant copying in the head of legal. And during that process, the head of legal came to the view that the claimant was questioning her integrity, and she made a complaint about that to HR. Now, the claimant brought claims of detriment and unfair dismissal. And in terms of the detriment, interestingly, the tribunal found that the head of legal had treated the claimant detrimentally during the course of that conversation in the manner in which the conversation went, and also subsequently by telling others that the claimant had questioned her integrity. However, that claim failed because it was out of time. In relation to the dismissal, the claimant was dismissed because she had questioned the integrity of the head of legal in that conversation and in the email. So in the same subject matter as the detriment claim that would have succeeded, but in terms of the dismissal, the tribunal found that the claimant had been dismissed because of conduct reasons, not disclosure. So they had separated the making of the disclosure from the manner in which the claimant had behaved in questioning the integrity of the head of legal. And the tribunal said the decision makers hadn't actually looked at the disclosures themselves and what had led to the meeting. So again, not a but-for test, but looking at what in the dismissal terms, what the principal or sole reason was in terms of the decision makers themselves. You can see there that first bullet point on the slide I've just moved to. The claimant had been arguing that the reason for the dismissal couldn't be treated separately and distinct. So that goes back to the separable that we referred to in Martin and Devonshire's. Claimant appealed. His Honour Judge Auerbach rejected that appeal. And for anyone who's going to read the judgment, in terms of the separability principle, at least paragraphs 81 onwards, His Honour Judge Auerbach recognised the fact that there had been a finding of detriment on the grounds of disclosure in relation to the head of legal's actions in that conversation. But it also the tribunal directed itself that because of that, it needed to treat this particular reason for dismissal very carefully. But in this instance, he said, His Honour Judge Auerbach said, the distinction could properly and genuinely be made when considering the motivation of the decision makers. Put it another way, he says the perceived personal attacks on the head of legal weren't a necessary part of the disclosure, and that the conduct was separable from the disclosure itself. Again, tribunal had been clear in the judgment as to what motivated the decision makers, and it being the way in which the claimant had conveyed to the head of legal her criticisms of the head of legal personally. But the claimant appealed again, and it went to the Court of Appeal, and that's the judgment that we see from back end of last year. But the claim to the Court of Appeal was similarly dismissed. Now, in terms of the concept of separability, and that which we discussed right at the start with Martin and Devonshire, again, for anyone who reads this judgment, paragraph 56 onwards is useful. That just reiterates that this distinction can be made. It says that the authorities recognise there may be in principle a distinction between the protected disclosure of information and conduct associated with or consequent on the making of the disclosure. For example, a decision maker might legitimately distinguish between the protected disclosure itself and the offensive or abusive manner in which it is made. Interestingly, the Court of Appeal went on to say this separability principle is not a rule of law. What it is a label which identifies what might be necessary in some cases as a step in the process of determining, as a matter of fact, what the real reason is for the impugned treatment, i.e. to get to the reason for the treatment. On some occasions, in the right case, it's a necessary step to go through this process of separating out or seeing if you can separate out a particular feature from the disclosure itself. Otherwise, says the Court of Appeal, whistleblowers can simply act with impunity when they're making a disclosure. Now, just finally on this, I said when I was discussing Devonshire that I'd come back to the phrase wholly unreasonable. And that's because in Kong, it was argued that if, say, the manner in which the disclosure is made is either not unreasonable at all, or is simply ordinary unreasonableness rather than wholly unreasonable, then the employer should not, as a matter of law, be able to distinguish between and separate out the disclosure from the manner of the disclosure. But the Court of Appeal wasn't impressed with that. It said Martin and Devonshire hasn't laid down a rule of law. There's no objective standard of reasonableness of the whistleblower's conduct, which will determine whether or not the separability applies or not. As we've set out in that slide, just bear with me. Third bullet point, even in case where the claimant's conduct cannot be said to have been unreasonable, a tribunal may still conclude that there is a separate feature of the conduct that's distinct from the protected disclosure. But of course, the more reasonable an employer's, the way in which an employee raises the disclosure, the less likely it is that the tribunal is going to accept that that distinct feature is the real reason for the detrimental treatment or the dismissal. As we can see in that final bullet point, that the detrimental treatment of an innocent whistleblower will be a powerful basis for particularly close scrutiny of an argument that the real reason for the adverse treatment was not the protected disclosure. So just drawing all that together and summarising, in the right case, on the right facts, the disclosure can be genuinely separable from other factors, such as the manner of the disclosure or the consequences of it. And that can be the case even if the behaviour of the employee is not unreasonable or ordinarily unreasonable. But of course, the tribunal, the courts are going to scrutinise these sorts of cases carefully. And this is why they're tricky, or can be tricky at least. Certainly the evidence before the tribunal is going to need to be absolutely clear on this point, but also from a client perspective, the contemporaneous documentation is going to have to be absolutely clear on what it is, or the reason for the treatment, either the dismissal or the detrimental treatment. And it's going to encourage particular scrutiny from tribunals where the behaviour of the employee is not or has not been unreasonable. Just going to pass back to Andrew to look at what I term the attribution principle.
Thank you, Tim. Well, as Tim mentioned earlier, the case of Kong also deals with the attribution principle. But before I get to Kong, I want to start with Royal Mail and duty. I suspect that many of you will have come across duty, it being a significant Supreme Court case, but for the benefit of those who are less familiar with it or haven't read it recently, it's sort of getting on for 3 years old now, I'll just re-summarise the facts for you. Ms. Duty made disclosures to her line manager, Mr. Widmer, to the effect that a colleague in her team, Ms. Mann, was or may be breaching Ofcom's guidance. So that's Ms. Mann and Ms. Duty and Mr. Widmer's team. In a meeting with Mr. Widmer, Ms. Duty was, or in that meeting with Mr. Widmer, Ms. Duty was given the impression, the distinct impression by Mr. Widmer, that if she was to pursue the matter, then her job would be at risk. He clearly didn't take kindly to his team being questioned, and Ms. Duty promptly withdrew the allegations. Notwithstanding her concession and agreement to withdraw the allegations, in the following months, Mr. Widmer went on to effectively prosecute a campaign against Ms. Duty, and in particular criticised wrongly and unfairly her performance, giving the impression that it was inadequate. To cut a long story short, ultimately there's a capability process and another manager, Ms. Vickers, who was not a party to that those sham and bogus criticisms of Ms. Duty's performance, criticised herself, Ms. Duty, and went on to dismiss her on performance grounds, Ms. Vickers having accepted at face value what Mr. Widmer had told her, and by that time Ms. Duty didn't really participate in the process because she'd gone off sick. So Ms. Duty went on to bring dismissal and detriment claims. The ET upheld the detriment claim, but it rejected the dismissal claim itself on the basis that the decision maker, Ms. Vickers, had genuinely believed that the claimant's performance had been inadequate, and that was the reason for the dismissal, even though Ms. Vickers had fallen into error and had taken at face value what Mr. Widmer had told her, despite it being wrong. Well, matter went to the EAT, who allowed the claimant's appeal on the dismissal point. The Court of Appeal then reversed that decision, and the matter ended up at the Supreme Court. And I've included, because it's as neat as any other way of doing it, the full quote from, or the full relevant part of the judgment, which if you bear with me, I'm going to read out because it's worth doing. In the present case, however, the reason for the dismissal given in good faith by the decision maker turns out to have been bogus. If a person in the hierarchy of responsibility above the employee, here Ms. Duty's line manager, determines that for reason A, here the making of a protected disclosure, the employee should be dismissed, but that reason A should be hidden behind an invented reason B, which the decision maker adopts, here inadequate performance, it is the court's duty to penetrate through the invention rather than allow it also to infect its own determination. If limited to a person by the employer in the hierarchy of responsibility above the employee, there is no conceptual difficulty about attributing to the employer that person's state of mind rather than that of the deceived decision maker. Excuse me, so that's duty. Since duty, the issue has come up in 2 or 3 cases of significance. It came up in the case of Fairhall, which is a local case for those of you listening in the Northeast. In that case, the claimant brought a successful dismissal, section 103A claim, but the Employment Tribunal's judgment observed that both the dismissal and the process itself leading up to the dismissal were infected and tainted by the disclosures. Was the Employment Tribunal in such circumstances entitled to uphold the dismissal claim without exploring in detail the motivations of the managers involved prior to the decision to dismiss, or does duty require the Employment Tribunal to conduct that wider inquiry? That was the issue that went to the Employment Appeal Tribunal, and the Employment Appeal Tribunal gave a very clear view that once the ET has reached the conclusion, as a matter of fact, that the dismissing decision maker had dismissed for the principal reason or sole reason that disclosures had been made, no further inquiry was required. And there was more than a hint from the EAT in that case that it doesn't expect to see duty cases prosecuted too often. Nevertheless, the matter came up again in Con. Tim has given you some of the facts of that case, which are germane to the separability principle, some of which are equally relevant here, but I just want to reiterate a few points for the purpose of understanding the judgment. So as Tim has said, the claimant had an argument with the head of legal, that was a lady called Miss Harding, in which the claimant questioned Miss Harding's professional awareness, and there was a view, certainly one taken by Miss Harding, that her integrity was also being questioned. That conversation took place, or argument took place. It was then followed up by an email exchange between the two of them. And Miss Harding then went to the UK Chief Executive, Ms. Garrett Cox, her boss, to complain about the issue, and she forwarded to her the email chain. Ms. Garrett Cox and then a lady called Ms. Yates, who was the head of HR, formed the view that given what happened, the claimant was going to have to go. So they arranged to see the claimant's line manager, who's a Greek chief auditor, a man called Khalid Mohammed, who importantly for present purposes was based in Bahrain and who sat outside the UK management chain. Anyway, they went on, as Tim was explained, to reach the view that the claimant should be dismissed, which she was. And as Tim's also explained, the Employment Tribunal went on to reject the Section 103A claim on the basis that the dismissal, principal reason for dismissal was conduct, not the disclosure. Well, insofar as the attribution principle is concerned, the claimant took the point to the EAT, and she argued that this was a duty situation, an attribution principle situation, by reason of the involvement of Harding in the lead up to her dismissal. Well, the EAT comprehensively rejected this suggestion, but importantly gave some clear guidance on what needs to be established if an employee or claimant is going to make out a duty or attribution case. And there are three aspects to it. The first two are on this slide at the bottom. So the first is that a person whose motivation is attributed to the employer must have sought to procure the employee's dismissal for the prescribed reason. Secondly, the decision maker must have been peculiarly dependent upon that person as the source for the underlying facts and information in the case. And then turning the page, thirdly, the person whose motivation is attributed to the employer must be more senior in the hierarchy than the dismissed employee. Well, in this case, the Employment Tribunal had not made a finding of fact that Ms. Harding had actually sought to procure Ms. Kong's dismissal, notwithstanding Ms. Harding's criticisms of her. It was Ms. Yates and Ms. Garrett Cox who had come to the conclusion that she had to go. Secondly, the decision makers were not on these facts peculiarly dependent upon Ms. Harding. They were aware for themselves of the general context and had seen the emails. And thirdly, given that Khalid Mohammed was in Bahrain and sat outside the UK reporting line, the hierarchical requirement wasn't met either. Given the multiple bases upon which the EAT found that the test wasn't met, it's perhaps not surprising that the claimant didn't go on to take that point to the Court of Appeal and instead only took the point which Tim has already covered. Turning to interim relief, another slight departure from the strict ambit of the talk, but one that I thought was mentioning, but principally actually because I had an interim relief application the other week in a trade union case. The context there was that, as it will not come as a surprise to anybody, there are obviously lots of strike actions taking place at the moment, and in that context, certain employers have been taking a fairly hard line on employees. They would say behaving inappropriately. The employees would say being dismissed on the grounds of their trade union activities. Anyway, that's a not directly germane here, but the interim relief application, which one can make in the union context, can also be made under a different provision of the Employment Rights Act in a whistleblowing case. They're not a very common application, certainly in my experience. So I thought it was worth mentioning it. And effectively, what you're looking for is a case in which a claimant has a very strong argument that the principal reason or sole reason for dismissal is that they've made a disclosure. If you do have such an argument, and they do exist, one does occasionally see employers who exchange emails and the like, which are not particularly helpful, to put it mildly. I had a duty type case myself in which just that situation arose, albeit only on a detriment point, not at a dismissal point, last year prior to Kong. But if one does have evidence of that type, then my view is they're worth considering because they offer significant benefits to the employee, to which I'll return. I say a strong case. Strictly speaking, Section 129 requires one to establish that it's likely that the dismissal will, the Section 103A claim will succeed. However, it has to be understood in the context of the case law. In this context, likely doesn't mean more likely than not. As was held in Safraz, what's required is a significantly higher degree of likelihood than just more likely than not. So you do really have to have a very strong case. But if you've got one, in my view, it's worth contemplating. If you are in that situation, however, do have careful regard to the statutory provisions, which are prescriptive, not least that such an application has to be made within 7 days of the effective date of termination, which is plainly quite a restriction. So it's probably a circumstance practically in which one is already involved prior to the date of dismissal. I should add that the one would present the claim at the same time, and the early conciliation provisions don't apply just to that particular claim, albeit they probably do apply to other claims. That's the subject of some debate. In terms of the benefits to the employee, which I mentioned, the Employment Tribunal has wide-ranging powers in such a circumstance, involving pending the final hearing of the matter, reinstatement, re-engagement, or alternatively continuation of contract. Exactly which of those options would be used would depend on the circumstances, if the employer objects to reinstatement and or re-engagement, then one may end up with a continuation of contract, but it would still have the benefit to the employee that they would continue to be paid until the final hearing. So something worth considering, and I thought worth mentioning. I think, Tim, that brings us to the end, subject to any questions. I'm just looking at the question boxes. There's a question on separability. I don't think, Tim, that you can see the question and answer session. So shall I read? If I read it, maybe I'm not sure whether
actually, Andrew, I've just managed to pull it up.
Can you see?
So I can see that one. Shall I deal with that one first?
Yeah, if you're happy to do that.
Yeah. So just looking at the question in terms of separability, could an employer put to the whistleblower that their account is contradicted, then set up the whistleblower as accusing another of not being honest, i.e. being a liar, and then dismiss for the manner of the disclosure? Or does the exact point in time the disclosure is made without any emotional baggage then attaching reduce a risk for the worker of a separability point being established? So essentially, can the employer back the employee? I think is meant by this. Can the employer back the employee into a position where they are essentially calling someone a liar and therefore dismiss for conduct rather than the disclosure? I suppose so in theory, but that probably goes back to the point that these sort of separability cases are going to attract particular scrutiny from tribunals, and they're going to look in some detail at what the reason was. And it perhaps also touches on the unreasonable behaviour stroke, ordinary unreasonable behaviour, or wholly unreasonable behaviour. You have to look further forward and to whether the tribunal is actually going to accept that. And if it's a situation where someone is being questioned about it or interviewed about it, and they're specifically asked, are you saying they're lying? Even if they say yes, is that the sort of behaviour that is going to persuade a tribunal that that's the reason for the dismissal or the detrimental treatment? It's probably not. It's certainly far less likely than, for example, perhaps the more usual side of the coin, whereas where an employee is raising a disclosure and making lots of allegations about liars or fabrication as they go along, and for example the PANEU case of campaigning. So long answer, but the short one is probably yes in theory, but the likelihood of that flying in tribunal is probably minimal. It's all facts specific, it's all degrees.
Thank you, Tim. I think the second question is probably one for me on duty. I'll just read it out for those that can't see it. It says this: duty in the real world, is there not usually an HR thread through investigation dismissal appeal, which actually makes it very difficult for an employer to say that one manager with HR support is oblivious to a real reason? I think that's almost certainly is the case, and that's really why the EAT and the Court of Appeal, etc., have said repeatedly that duty situations will be rare. But rare is not synonymous with do not exist. I mean, clearly they existed, for example, in duty. I had the case that I mentioned in which these issues came up. I think Tim's had a case as well. So they do come up, but absolutely these are not situations which are going to arise too regularly. But you know, one will get managers who go out of their way to give an unfair impression of people with a view to getting short of them. Whether one can link that to disclosure, I suppose, is another matter. But I take the point. It's not going to be too common an occurrence. I think, Tim, that is the extent of the questions on the Q&A at the moment. And I'll just give everyone a minute in case there are any other questions to type them into the Q&A. Whilst I'm doing that, I will mention that the next Law with Lunch is going to be taking place on the 27th of February on the subject of flexible working, and that's being given by our colleagues Nicola Twine and Sophie Watson. And I'm told that there'll be emails coming out about that in the near future, so look out for those. I can see there's a question coming from Sarah asking for copies of the slides, which I'm sure can be circulated. We'll see. I'll speak to the clerks about making that happen. Apart from that, it looks like there aren't any other questions. Tim, I don't know if there's anything you want to say by way of conclusion.
No, I don't think so. I think we've covered everything. Thanks, Andrew. I can't see any more questions. So just to say thank you very much for everyone joining us.
Yep, thank you very much, everyone. Bring the session to an end now.